Welcome to Connect. I'm Cheryl Tan. Today we're talking about estate planning with George Dillon and Chris Pachta from Dillon Law Group, specifically the difference between a living trust and a simple will. So let's start with you, George, and tell us about a simple will.
Sure. Really, a simple will is a roadmap for your loved ones upon your passing to explain to them your intended distribution for your assets, what you want done with, for example, minor children, who you want to take care of them, and how your debts are going to be satisfied. Really, what we like to think of when it comes to a simple will is it gives that framework for the distribution of your estate so your family members can really focus on the grieving process and really celebrate your life, as opposed to getting caught up in the minutiae and the details of winding down your estate.
And it's really a start.
It's a start. It's a foundation.
It's a foundation of what is necessary. Chris, how about a living trust?
Well, a living trust, similar to the will, is a legal document providing for your assets and the distribution of those assets upon your death. However, as contrasted with the will, the living trust is just that, a living document. So it's created during the lifetime of the client and provides instructions for placing assets in that vehicle, which is the trust, here and now, and then providing for the distribution of those assets in the future upon the individual's death.
How do people know which one they need?
Well, oftentimes when we sit down with clients, we'll first discuss their objectives, their goals, and that will determine in part whether they need a living trust or a will. But also, what is their portfolio? Where are their assets located? Do they have multiple items of real estate, multiple assets in multiple jurisdictions and states? And all of that will go into determining whether they need a living trust or if a simple will do.
Some people, after they've decided to get a will, get a trust, they sort of set it and forget it. But things happen. They maybe get married again. They have more children. They acquire more assets. When should people revisit these documents?
That's a great question, Cheryl. Really, a lot of people think that these documents are a set it and forget it scenario, but we recommend that you visit your estate plan at least on an annual basis, maybe even more frequently than that. Events happen. You have divorces, you have marriages, you have new children, you acquire new assets. Really, when it comes to estate planning, this is a very organic living process, and so you want to make sure that you develop a long-term rapport with that estate planning firm and your attorney. Our advice is do it now.
George Dillon, Chris Pachta, Dillon Law Group, thank you very much.
Thank you.
Thank you.
Watch Connect Sunday mornings at 9 on 13 News Now.